If it matters to the people of Tipperary, it's on Tipp Today with Seamus Martin.
Unmarried Tipperary fathers are in a kind of a limbo over multiple legal loopholes. They don't have automatic rights to guardianship, custody and even access to their children. But more importantly, I suppose, let's say there has been a relationship with somebody outside the jurisdiction and they want the mother wants to leave to go back to her home country. There's nothing the unmarried father can do about it. Let's talk to Maria Connolly. She's a solicitor. Let's talk about this. Maria Connolly, good morning.
Good morning, Seamus. How are you?
Oh, not too bad. So is there anything that a person in that position, a man in that position, can do?
At the moment, Seamus, what they have to do is they have to take certain steps to obtain guardianship. Now, they can do that with the consent of the mother if she's willing to sign a declaration. However, if she's not, then they would have to make an application to the court to become a legal guardian of the child. And guardianship is what gives you the right to decide what jurisdiction your child lives in and indeed where they live, and the right to actually apply for a passport for your child. So at the moment, unless an unmarried father has obtained guardianship, he has no right to apply for a passport, nor has he any right to decide where the child resides.
And if he goes to the courts, then are the courts generally willing to grant that?
Absolutely. I mean, the courts recognise the role fathers play in the child's life, and it is something that they're very conscious of. And if the father is carrying out his parental responsibilities, there is absolutely no reason why he wouldn't be granted guardianship. In most cases, they are.
And in the event then of a kind of a tug of love situation, as I started out explaining, if the mother wants to go back to her own country, if she's from outside the jurisdiction, what happens then if the father is a legal guardian?
If the father is a legal guardian and the mother relocates without having obtained the consent of the father, that is considered abduction. And if she goes to a country which is a part of the Hague Convention, then steps can be taken for the immediate return of the child. However, if the father hasn't been appointed a guardian, it's much more difficult to have the child returned here.
Yeah. So she can't go abroad with the child without the father's consent?
She can't, not legally.
Yeah. See. And some people would say that that's kind of unfair, in a way.
There is an equality. Well, yes, it would be considered unfair. However, if she makes an application for relocation, and the court looks at it and is in the best interest of the child, then they will facilitate it. But it must be in the best interest of the child as a whole, and they have to take into consideration the rights of the child is the paramount concern, but also the rights of each parent as well.
And what about if there's a kind of a de facto situation that the mother has left, and say the father is the legal guardian, but he wasn't aware that she was going to snatch the child or children, and they're gone? What happens then?
That child has been removed from the jurisdiction illegally. That is considered parental abduction, and steps can be taken. Provided the country to which she has travelled is a party to the Hague Convention, then steps can be taken for their speedy recovery, for their speedy return of the child to this country.
And would most of the countries that we, in Europe and maybe North Africa, would they be signatories to the Hague Convention?
Absolutely, most of those countries are. It's the more third world countries that there would be an issue with.
Yeah. Now, does the father have to prove paternity?
Does the father have to prove paternity?
Yeah.
In circumstances where it's being contested by the mother, it would maybe require that a paternity test would be carried out. But if the father wants to prove it, and he is, he would be more than happy to arrange for that, as would the mother if she wants to disprove it. So,
yeah, but applying to the courts, then that probably doesn't come cheap, does it?
It depends. I mean, in some circumstances, more recently, more and more people are eligible for legal aid, and the legal aid boards are absolutely inundated in relation to family law matters at the moment. And if you speak to any of them, they will tell you that it isn't cheap otherwise. I mean, if you have to go to a private practitioner for any reason, yes, it wouldn't be cheap. And certainly where there has been abduction proceedings has to take place, and that involves the High Court, and it wouldn't come cheap, no.
Yeah. What about custody and access then?
Custody and access, I mean, there is access to the district court in relation to those issues. You make an application pursuant to the Guardianship of Infants Act 1964. So it's easily, access to the courts is quite easy. And as I say, the judges are very conscious of the role of the fathers. And the role of the father in the child's life has increased as years have gone on, and in the last few decades they are more and more involved in the upbringing of their children, and the courts have moved with that. However, the legislation unfortunately hasn't, and this lacuna has existed, in that there is an inequality there between unmarried fathers and married fathers.
So what kind of legislation could be brought in? Could it be brought in easily?
Well, the Law Reform Commission have done a report on this, I think, in around 2010. And what they have recommended is that the unmarried father becomes an automatic guardian on the joint registration at birth. So, in other words, when the birth of the child is being registered, that both parents are now put on the birth certificate, except in very limited circumstances, and then the unmarried father would automatically become a guardian at that stage.
Of course, to turn it completely on its head, is often the opposite happens, that the unmarried father is not willing to take responsibility of any sort for his child.
That has been a concern of the Law Reform Commission in the past, in that when they do become a guardian, they would then have a veto on relocation, and I think you touched on that before, and on all rights of the child, that they would have a veto and would have to be consulted. But in recent years, certainly society has been changing. Fathers are much more involved in the upbringing of their children, whether they're unmarried or married, and want to be involved. And it is recognised that they do have a great role to play in the upbringing of their children.
What about if the relationship has broken down and the couple are no longer together, and access, custody might have been decided in favour of the mother, but access might also have been decided, but it's being frustrated by the mother? What can a father do in a case like that?
Well, obviously they would have to bring it to the attention of a judge if the access order was made on foot of a court order. What needs to be done there, and I've seen a lot of judges passing comment on this from the bench, mothers should encourage the relationship between father and child, because it is very important that is done. And yes, there for whatever reason there are circumstances where mothers do make it very difficult for access to take place properly, and but they do need. It is encouraged right from the bench that they encourage their children.
My question is, Maria, what kind of sanction is there against a mother who continues to frustrate the access?
Basically, she is in contempt of court, and she has to be brought back to the court to purge her contempt in that regard.
But ultimately, if she refuses to do that, what would happen to her?
Well, obviously, the ultimate sanction a judge can pass down is a jail sentence. Now, they would be very reluctant to do that in family law situations, because
that's what I thought.
Yeah, they are very reluctant to do that.
But
that is the ultimate sanction.
But that is a tricky one too, isn't it?
It is. Yeah. But what I have seen judges passing comment from the bench, that this must be encouraged, and basically handing out warnings in this regard.
And usually, do the warnings work?
Eventually.
Okay.
And most mothers do want what's best for their children. Most parents do.
But sometimes a child can be used as a kind of an emotional pawn.
That's very much accepted.
Yeah. Okay. But generally speaking, from your attendance at these family law courts, do the parents, even though they're estranged, do they take the child's welfare on board, or are they kind of looking after their own welfare?
Well, there can be an element of that, and unfortunately it's unavoidable. We as solicitors, or certainly I feel I have a role to play in encouraging my clients that, the child is the paramount concern to the court, and that is the situation. And all judges, in my experience, the child is of paramount concern to them.
Now, we've been talking about, relationships where they're not married, when they are married and the marriage breaks down, a divorce, is it something similar?
Oh yes, the same situation arises.
Yeah, and the same tensions, I suppose.
Exactly. Well. Yes. The child, unfortunately, is used as a pawn in a lot of family law situations.
Yeah, but when again, the same thing with a divorce situation. Now, say we're living in difficult times, and say there's no work in Ireland for a particular person, and say he or she decides, look, I'm going to Canada or I'm going to Australia, and I'm bringing the children. I mean, can they do that?
They must make an application for relocation.
Yeah.
And it is quite difficult to get that.
Yeah, but if they can make the argument, look, I can't get work here, and I need to bring up the children. I'm the person with the custody of the children. So, I need to get work. I can't get work in Ireland, so I have to leave. That must be a heartbreaking situation for the other parent.
Yes, but what I would say in those circumstances, it is quite difficult to get an order for relocation.
Is it?
Yes.
Yeah. The courts don't look on it.
They don't hand them out liberally. Definitely not.
And would they take a view that if the children were older, they might hand them out easier, or what?
Well, it would be easier for the children to maintain contact with the parent who stays in this jurisdiction themselves by travelling forward and backwards and farther. It is easier. It's much more difficult with small children because small children have to be accompanied when they're travelling. They can't speak for themselves. It is absolutely much easier to facilitate an arrangement like that, and to facilitate more regular contact when the child is older.
All right, thank you very much for talking to us, Maria Connolly.
Thank you, Seamus.
Yeah, it's a tricky subject. That there's an awful lot in it, and an awful lot to be considered, and human dilemmas, left, right, and centre, and maybe no particular right and wrong in it. It's not a black and white situation.